But this is an introductory lecture. How is employer's liability broken down? I want to outline for you the three bases of employer's liability. It's a nutshell lecture in that sense, but I think it adds quite a lot to the textbook analysis. Firstly, I'm going to spend a bit more time on the history to explain why we have a threefold division of employer's liability. I'm keen on history, as you know. I'm going to compare the merits of the three bases of action in ways, I think, which the textbooks perhaps don't do. And importantly, I want to discuss the recent statutory changes, the important changes made in 2013, which have changed the rules here. The textbooks I'm not altogether happy with. The treatment in the textbooks is a bit dated. There's insufficient detail, especially about the statutes. They don't take a practitioner's view in many respects. They don't take into account the issues which are encountered in practice. They're written in a very abstract, non-practical way by academics who have not been involved in the field. I've tried to cure a little of that in the lecture today. I could start by a very practical 2 slides, which aren't included in the employer's liability chapters of the textbooks. These are the sorts of things I'd want up front in my chapter on employer's liability. I'd want to start by saying, there's money here. Employer's liability was made compulsory in this country in 1969. Of course, many people took out employer's insurance far before that, but it became actually compulsory in 1969. The one other area where it's compulsory to have insurance is in relation to road traffic injuries. And it's no coincidence that road traffic injuries in the law of tort comprise 80% of tort claims for personal injury, and employer's liability comprises 10%. So, employer's liability and road traffic injuries, 90% of all claims, because there's a guarantee of money at the end of the rainbow. We know there's damages to be had in these areas. You're not having to sue individual people to get money when, obviously, for the vast majority of defendants, especially in road traffic, they're not worth suing. Well, how much work is there? Well, I've already said it's now 10% of all personal injury claims. About 89,000 claims last year, of the total of about 900,000 claims, almost a million, 900,000, work injuries are 10%. The percentage has declined. You can see in 10 years it's declined from 20%. It used to be 20%. And if I go back to the 1970s, it was 45%. Half the work for personal injury lawyers was work accidents, work injuries. Now it's only 10%. But perhaps I can encourage you to study the subject a little bit, insofar as asking you the question which I'll come back to next semester when we talk about your future work possibilities in personal injury, in tort. Where will you eventually work? It's very difficult to get training contracts, as you've gradually discovered now. Many students have to graduate and then go into paralegal work, which I shall talk to you about next semester. A lot of that paralegal work is in personal injury work. We're associated with Hugh James, a lot of people working in paralegal personal injury work. Some people will eventually end up specializing. In my causation tutorial this morning, I mentioned the fact that there is a specialist group within Hugh James which deal with mesothelioma, which deal with asbestos-related diseases. Employment generally, specialized group. It may be that for a few of you in this audience, you will spend your rest of your working life with this lecture. This lecture is just going to form the foundation, a nutshell foundation to what for some of you will be an important part of your career. I wonder who that's going to be. In work accidents, disease is more important than in other areas. You know, road accidents, you don't think of disease, do you? So you would expect it to be a high figure. For tort in general, there are 29 accident cases for each disease case. How can I say that? Because I explored the statistics in an article I wrote for the Industrial Law Journal 2 years ago. And these are the stats, which aren't appearing in any tort textbooks. But for work accidents, it's not 29 accidents for every disease case. It's 2 accidents for each work disease case. Diseases are far more important, as you'd expect, in a work context as opposed to road traffic. But disease generally is very much undercompensated within the tort system. And if I just move to, this is a TUC claimant, Trade Union Council. Trade unions have claimed that only 1 in 7 workers who are injured actually make a claim. There's especially a low rate of claiming. People underclaim for, and typical underclaimings I've listed here, musculoskeletal disorders, in other words, bad backs. We no longer have the pneumoconiosis of coal miners, thankfully. We no longer have the injuries to those working in the iron and steel industry because we don't have an iron and steel industry or coal mines. We've moved into office jobs. And what's typical of office jobs? Musculoskeletal disorders. I used to look around at the chairs supplied for the lecturers 20 years ago, and none of them complied with ergonomically efficient anti-bad back guidance. We all could have been suing the university for our bad backs. Nobody has. But quite a few people suffer. Stress and mental injury are very much undercompensated. Only 2% of the claims for disease are stress and mental injury cases. For mental injury, as we shall see when we come to the duty of care, that there is a problem in bringing claims for mental injury and stress. And we know there's a lot of stress related to jobs. Those cause heart attacks. How many heart attacks get into the tort system? Because of stress at work? Oh, very, very few. I could simply say the same about cancer. Cancer is widespread, large numbers of people injured, die from it. We know that cancers can be connected to work. Very few people make the connection with work. There's a lot more injuries and death at work than actually is claimed for. You know, what's the factors affecting that? We're going to talk about that next semester. But I thought I'd list these here for now anyway. On the one hand, we would expect more claims, wouldn't we? Because trade unions give you free representation here. Here's the strength of the trade union movement, is that it'll supply legal advice to you for free. You'd expect more claims, because you've got ready access to the legal system at no risk to yourself. But on the other hand, there's these factors here which militate against claims. You may not realize that your disease or injury is caused by work. The lung cancer you've got, it could have been exposure to asbestos, but you just don't associate. You think it's all your fault because of you smoking. You don't associate it with work injury. I still today meet people who are frightened of suing their employer. They think they might lose their job as a result. There could be employment repercussions if you start being adversarial against your employer. You might blame yourself. You might not appreciate, it's the system at work that is causing your injury. You might say, well, it was my fault, really. But in fact, you've got the wrong equipment. In fact, the job has not been set out properly. Or you blame your fellow workmate. You don't want to sue because you blame your friend. You blame your workmate. You don't want to sue because you've only suffered minor injury. It's not worth it. Especially when, in some jobs, there's very good sickness or pension schemes which will continue to pay your wages even if you were laid off work. University is very good like that. I could be away from work for a whole year and it would still pay my full payment, my full wages. I would suffer no financial loss at all. So if I was injured, then the only incentive for me to sue is to sue for damages for pain and suffering. My financial loss will be covered effectively by my work's sickness scheme, my work's pension scheme. So there's some reasons then why you don't sue and why we're undercompensating work accidents, but it still comprises 10% of tort claims. Now let's move on to the nutshell view of tort, if I can put it that way. I'm going to divide the threefold basis of liability in the following ways. I think you know what vicarious liability is. Vicarious liability through another, visa, through another, in the Latin. Where the claimant sues, he sues the employer, but he sues because of the fault, the tort of the employee. You get the employer by going through the employee. I'll explain that again in more detail in a moment. That's different from a breach of a common law duty. A common law duty, this is a duty directly placed upon an employer. It's not a question of suing because of the fault of the employee. You're suing the employer direct because of his own breach of duty. And that's a common law duty, so it's a judge-made duty. Common law, judge-made. As opposed to, thirdly, breach of statutory duty. Again, it's a direct duty upon the employer. It's not suing for vicarious liability. It's not suing through an employee. It's the employer's own breach. But this time, instead of it being the result of the judge imposing a common law duty, this is a statutory duty. It's a breach of statutory duty, a statutory duty made by Parliament. There you have a simple division. Let's look at it in slightly more detail. Let's take vicarious liability first. Well, vicarious liability was due to be dealt with in the next lecture or in the last lecture. I'm not sure. Vicarious liability was the first of these three bases to develop. You can go back to medieval times. The rules were made by judges. It's a common law. It's nothing to do with statutes. It's judges. And you were liable for the fault or the breach by the employee for which the employer was responsible. So, first of all, you're only liable for employees. Now, the definition of what's an employee can be very vague and very uncertain at the edges, but by and large, the old-fashioned textbooks in tort used to talk about master and servant, employer and employee. They still sometimes use the words master and servant in tort textbooks, extraordinary at times. But an employee is somebody who directly employed, was not an independent contractor. The old textbooks used to say, your chauffeur is your independent, is your employee. Your chauffeur you employ is an employee, whereas your taxi driver is an independent contractor. You know that you've got the idea. And your liability for the employees and not for independent contractors, your liability is the secondary liability. You're liable as an employer for the fault of the employee. You're liable for the fault of the servant, for the fault of the employee. And the liability of the employer is strict. Even if the employer couldn't have done anything about it, he couldn't have stopped that bus driver being negligent as he was driving down the road any more than he should, the bus company is going to be vicariously liable. Even if they'd done their very best to choose the right driver, to give them all the instruction they could be not at fault at all, but they are liable because they're liable for the fault, the breach of the employee. And the claimant here could be anyone, a passerby, a visitor, an independent contractor even. It doesn't have to be an employee. So the claimant could be anyone in the world who's injured by the fault of the servant or employee. That's distinct from the common law duties. Now, the common law duties arose much later, in the 19th century. We can't trace these back to medieval times. I'll explain why they were developed in a moment. And here, the duty, as I've said to you already, is owed directly by an employer. Placed directly upon an employer. It's a primary liability. It's not secondary. It doesn't go through the employee. The claimant is able to sue the employer directly. There's no need here to rely upon vicarious liability. This is an avoidance of problems with vicarious liability. The claimant here, though, instead of being anybody in the world, as it was for vicarious liability, here they must be an employee. The common law duties are only owed to those who are employees, not to the world at large. And then, again, to finish off, let's move to statutory duty. Well, statutory duty, although it existed in the 19th century to some extent, it's really in the 20th century that it was developed. It was, as we shall see, it was abolished in 2013. I'll come on and explain that. This, again, is a breach of a primary duty owed by the employer, put upon him, this duty, by Parliament, not from judges. This comes from the health and safety legislation we've had in the late 19th and 20th centuries. what we know, and I think you might have heard of, the Factories Acts, the Health and Safety at Work Act, the Mines and Quarries Act, the Shops, Offices and Premises Act. A series of legislation coping with health and safety at work. Again, it's a primary liability, so you could actually don't need vicarious liability. It's the employer itself who has broken his duty. And this legislation derives from what were criminal statutes. Effectively, the Factories Acts, the Health and Safety were criminal statutes seeking to impose penalties on deviant employers. But the judges in the 19th century, early 20th century, started reading the criminal law into the civil law. This is the one area where, for breach of statutory duty, this was the important area which got into the law of tort. Remember I said to you, when I lectured upon breach of the standard of care, generally the breach of a statute, breach of a criminal law statute is not definitive of the civil law. Well, here it is, or was definitive of the civil law. This is an exceptional area where those criminal law statutes really are important. There's two key differences which run through these three issues of these three bases of liability. The first one is the common law duties and the statutory duties are called non-delegable. You see that, non-delegable. They cannot be delegated. They cannot be given to somebody else to do for you. You can't avoid them as an employer. They're non-delegable. You can't engage an independent contractor to come in and do this work for you. You can't engage an independent third person who you wouldn't be liable vicariously for because he's an independent party. He's an independent expert. You can't avoid the liability, though, because you're not suing for vicarious liability. In the breach of common law duties and statutory duties, these duties have been placed upon you as an employer. You cannot avoid them by getting somebody else in to do that work for you. By contrast, vicarious liability, of course, can be avoided. You're only liable for the liability of your employees. And if it's an independent contractor, you're not responsible for the taxi driver. You are responsible only for your chauffeur, to use that bad example. Fault. Well, we haven't moved that far away from fault. The course has been about fault up to now. Well, this is not much different. Vicarious liability, employee fault is the usual basis of the claim. You've got to prove the employer is strictly liable, but only strictly liable for the faults of the employee. So fault is very much part of the claim. And the common law duties, as we shall see, are essentially fault-based. The statutory duties, as we shall see, has some strict liability, was there. But by and large, fault dominated all of these things. Let's move on. Deal with some history rather speedily, if I may. I like a bit of history to understand things better. I told you already the vicarious liability developed first, and then the common law duties grew up from the 1850s or so. Judges made these duties in the 1850s onwards. And then the statutory duties, which from the end of the 19th century into the 20th century. So that's the historical theme, vicarious liability, then the common law duties and the statutory duties. And back in the 19th century, remember that history lecture at the start of the year I gave? There was something called, what Fleming calls the unholy trinity of defences. The three defences which stopped you being able to sue. Do you remember the lecture I gave when I said, well, it wasn't really the rules that stopped you being able to sue. You didn't know the law, you didn't have access to the law. There were all sorts of reasons why you wouldn't sue. And it wasn't the legal rules, it was the law in practice. Remember that? But there were the legal rules, and these were rules which were applied very harshly in contributory negligence, remember? Before 1945, contributory negligence was an absolute bar. Any fault on your part, 1% at fault, no recovery of anything. Consent was unfairly found. You knew it was dangerous when you took the job to work on the mine, therefore you can't sue the employer. Very harshly applied. But and everybody downtown knows of consent nowadays, knows, I've gone through that with you, contributory negligence, they're all familiar with those two defences. The defence they don't know about downtown is called the third defence, common employment. They have nothing to do with common employment. It has been abolished. But historically, it is very important. Why? Because the defence of common employment stopped you suing vicariously. Why? You were not able to claim if you were injured by a person who was in the same employment as you. Think about that now. You were not able to bring an action against the employer if the person that injured you was also working for the same employer. Can you see how that bars so much vicarious liability? Vicarious liability is being stopped because of common employment. A bit of history. I'll give you the case where it all comes from. The first case which an employee is sued by an employee in the law reports is Priestley and Fowler of 1835. It's to do with a butcher's cart being overloaded by the servants or the employees of the butcher. And as a result, it gives way and injures another employee. Okay, they overloaded the cart, injured another employee. The employee sues for the first time an employer, the butcher. Had there been a passenger on the van being able to sue, he would have been able to sue. But in this case, it wasn't a passenger or a passerby. It was a fellow employee who was suing. And this case was thrown out by the House of Lords. They said there was no liability. You were in common employment with the person who caused you injury. And the common employment rule was invoked to prevent actions based upon liability of a fellow employee. I don't want to go into the history of this too much, although it's quite fascinating, I think. I like the sort of policy discussions there is in the history literature, how the judges were worried about it. This is a Pandora's box. We could have all sorts of things happening if we start allowing claims by people who are being injured by overloaded butcher's carts. We could have liability for the negligence or drunkenness of the coachman if the footman was injured. God, shocking. There could be liability for the household cook if she served bad food. Oh, God. I like the throwaway line of one writer who said, Lord Abinger, who was the major judge in the case back in 1835, Lord Abinger may well have been thinking of his own lifestyle. Yeah, Abinger owned a castle near Belnevis, a Victorian household, and you can see these law intruding into such a Victorian household. I'm not sure we don't want the laws to interfere with things like that, do we? We don't want laws interfering with the happiness of the household family. No. And perhaps there's a worry of collusion between employees, I don't know. But I label it as the compensation culture case of the 19th century, if you like. It's an attempt to stop claims into familial groups or larger household groups, like those who work for one master. But it wasn't just the household that the defence was brought into. It was extended into industries. You see there, when train drivers had a head-on collision because of the negligence of one of them, the injured driver could not sue the employer of both. If they were both employed by the same company, they couldn't sue. The passengers could sue because they weren't in common employment. But the drivers were. And something that strikes home in Wales, of course, when the lift cage, when the cage taking the miners down the pit, failed because of the negligent maintenance of one of the staff or the negligent operation of it, no claim. They were fellow servants of it. They were all working for the same employer. And the judges, having made this rule in 1835, then realised they'd made a bit of a cock-up. This is very harsh, and they need to get round the rule. How are you going to get around the rule? This rule which barred a vicarious liability claim. Get the idea? Common employment is going to bar the vicarious liability claim. Well, one way of getting around the rule is to say that this isn't a case of vicarious liability. This is a case where you can sue the employer directly. The common law duties were placed by the judges in the 19th century directly upon an employer. And that enabled them to find the employer liable even if they couldn't be sued for vicarious liability because of the defence of common employment. It was a way of getting around the defence of common employment. Vicarious liability, therefore, increased so that nowadays it's the major cause of injury of employees. employers, of liability of employers. So that's why I say people downtown have never heard of common employment, but it has affected them. They don't realise that after common employment died, vicarious liability increased. And that's why they're working on vicarious liability today, because common employment eventually died out and was overtaken by these rules which placed direct common law and statutory duties, and eventually common employment was abolished in the 1940s. The judges got around the rules in other ways too. They started saying, oh, well, common employment does not apply if you're running a public risk. So that if two buses were injuring one another, smashed into one another, and you were both working for the same council running the bus. No, injuries on the road are a public risk. It's not just all employees who are affected by that, it's a public. So we're not going to apply common employment in relation to road traffic, for example. That was another way of getting around common employment. But the important point is that common employment, when it was removed, it led to an increase in vicarious liability, which is now the main basis of liability. And the defence of common employment was eventually, it was overtaken, it was forgotten about, and it was eventually abolished in 1948. But those downtown know nothing of it. Practitioners are pretty ignorant of that, because it doesn't affect them anymore. Right, let's go through the duties of the common law duties. I got 4 of them. There are 4 common law duties to look at. Here we are dealing with the first one. The duty to provide a safe place of work. These duties are very broadly based. You've got to provide a safe place of work. So the judges push that upon an employer. What does it mean? Well, they interpret it to mean the access to the work has got to be clear. There should be no obstructions. You shouldn't be hitting your head as you go in. You shouldn't be falling over things on the floor. The ventilation should get rid of the cotton waste causing bisonosis. It should be clean. Should not be subject to problems, toilet facilities. That's the sort of thing which has been interpreted as. But it's a very broad common law basis here. Just you've got to provide a safe workplace. That's very vague, very uncertain. What does that really mean? Well, we've been helped. We've been helped in working out what this means because there have been statutes. These health and safety at work statutes are much more detailed. They will tell you precisely what sort of equipment you need to ventilate a cotton mill, or how many toilets there should be per employee, where those toilets should be situated, and so on. They've got very great details here on the safety of workplaces. So there's much more information to be found in statutes, which can flesh out the common law. Note that we're still talking about fault. You're not going to be liable for a reasonable employer. The test is a reasonably prudent employer, the reasonable employer. Fault is still, it doesn't mean to say the workplace has to be completely safe, as you'd expect. There's not strict liability here in that sense. It's a fault-based liability. It all depends on the circumstances and the nature of the place of work. If you act as a reasonable employer, even though we all know that there could be inevitable accidents caused at work, well, if you're not at fault because of the safety of the workplace, you're not liable. Fault is the essence behind a safe place of work. Let's move to the second. The second of my 4 duties. Provide adequate plant and equipment. So as an employer, you've got to provide people with the tools to do the job. They've got to be provided with the proper tools, the proper safeguards, proper safety equipment. You've got to maintain those tools as well, very important. The textbooks do get into one area. I don't know why they do this, but all of them record the following statute. They don't record the other statutes I've given you so far, the health and safety at work ones, far more important overall. But this particular statute, the Employers' Liability Defective Equipment Act, does get mentioned. Why is that? Well, there's a technical rule, if you like, that employers are only going to be liable for fault. But wait a minute. There was no, therefore, common law liability if there was a hidden defect in equipment, if there was a tool which was badly produced so that it would splinter and split when it had pressure, perhaps. And you can't see this defect in the tool itself. It's only when you start using it that it becomes apparent. You as an employer could have bought a perfectly reasonable tool as far as you're concerned. You don't know yet there's anything wrong with it. You don't know there's any fault with it. But when they start using it in the drilling machine, it dissolves and goes into the employee's eye, for example. At common law, there's no liability because there's no fault of the employer. That was changed. This is noted in all the textbooks. In 1969, the Employers' Liability Defective Equipment Act said an employer is strictly liable even for the fault of the manufacturer. Even for somebody who is not an employee of his, he's strictly liable for the fault of the manufacturer in producing that. It still may be the case that the employee could have difficulties when they sue because they've got to show that the injury was caused by the equipment and there was a fault in its manufacturer. But the Employee Liability Defective Equipment Act makes the employer strictly liable for the fault of a manufacturer who is independent. The third common law duty is to provide competent staff. This duty has been overtaken in many respects by vicarious liability, but you've got to provide people who can do the job. That doesn't mean to say they absolutely guaranteed their safety. No, but you've got to provide people who are able and competent to do the job. This is still of some use because under this rule, don't forget, these are non-delegable duties. So here, an employer can be liable, even for an independent contractor. If he gets an independent contractor in to do the work and he fails to do things properly, even though he took all the care that he should, if the duty is directly placed upon the employer will be liable. Even though he wouldn't be liable vicariously, he could be liable for an independent contractor, and even for an employee acting outside his employment. If the employee is acting outside of his employment, is not doing what he's supposed to do, he can still be liable here. They wouldn't be liable in vicarious liability, but they could be liable for breach of common law duty. Let me illustrate that with Hudson and Ridge. It's an employee who's employed, and it turns out that he's been fooling around. He's keen on practical jokes, and sure enough, after a while, nothing was done to stop this. The claimant is tripped up and severely injured as a result of the pranks being played by this particular employee. The employee could argue, well, look, he wasn't employed to cause pranks. I'm not vicariously liable because he's acting outside his employment. That wasn't his job to fool around in that way. Well, he could argue that, but he would lose because this isn't a vicarious liability case. This was pitched as a breach of a common law duty. The employer ought to have known that that person was a prankster. He ought to have taken measures to check as to whether that person was going to perform practical jokes. He was at fault in selecting that employee, and although he's not vicariously liable, because he may well have acted outside the course of his employment, the faulty employee, the employer's liable because the staff were not competent. Note that if you couldn't have known, if the right employer could not have reasonably known that this guy was a joker or a prankster, there would have been no liability. The employer is only liable for his fault. He ought to have known or ought to have done something about it. But it's a direct duty placed upon the employer. The fourth of the common law duties is to provide a safe system of work. I always like this one, and if ever I have anything to say, and I don't very often, on work accidents, I would say you should think about always including this in your pleadings, the duty to provide a safe system of work. Why? Well, it's vague. I like the vagueness of this in pleadings. I think it's the most important of the common law pleadings, in my view. So that, for example, you can see that something's gone wrong in that work process. You can see that they haven't managed it properly, but you can't really work out who should have done what. But overall, there's a fault in management here. They haven't warned, they haven't instructed in the way they should. I'm not sure who's responsible for doing that, but there's a cock-up. If in doubt, I would plead failure to provide a safe system of work, because it's suitably vague. I have given sort of what it might include, those sorts of factors there, duty to organise work, provide instructions, and to ensure they're observed. But I quite like this one. Let me go through some cases very quickly. PAPE, for example. You've got to give gloves to a cleaner to avoid dermatitis. But you should be warning him or her about the danger as well. You've got to tell people what they're coming up against. Failure to provide a safe system of work. And in Nolan and Dental, if it's especially dangerous, you've not only got a duty to warn, but you've got a duty to supervise the protective equipment as well. Very important. And an old case like general cleaning contractors and Christmas, you can see that the employer got the window cleaners, but when it came to how they should clean the outside of the windows, the poor old employees were left to their own devices, and they decided they'd open the window and get out on the ledge. And sure enough, it ended in disaster. And the employer was liable because he failed to install a safe system of work. By leaving it to the initiative of the individual employer, the employee, the individual worker, there was no safe system of work. You can't just leave things to the employees themselves. You've got to instruct them. So these are very pro-claimant cases, favouring claimants. I now come to a case which favours actually defendants, although I think it's an old case. It's cited in the books, but nowadays I think I would be very upset if this was followed or if I couldn't get around it. What's the case? Cummings and Williams and Arrell involved the failure of the employer to give safety equipment that was needed. Failure to supply a safety harness. And the employer said, well, okay, yes, I'm at fault. I've done wrong. But I shouldn't be liable. I shouldn't be liable because if I'd given my employee a safety harness, he wouldn't award it anyway. Safety equipment, of course, is viewed as very burdensome by many employees. Safety equipment slows the job down. Safety equipment can be hot, uncomfortable. Safety equipment stops you earning money if you're being paid piece rates. Your productivity declines. So there's a great tendency to reject safety equipment in all sorts of respects. So you could imagine that this defence, this is a 1962 case, could be quite important to employers. Yeah, we didn't provide them with safety equipment, but they wouldn't have worn it anyway. Causation argument. We failed to act as we should have done, but the cause is not our failure. It would not have been worn anyway. It's causally irrelevant. It's all the employee's fault. Used causation completely to defeat a claim. I think this case could be got round, don't you? The duty nowadays, as Nolan points out, a little late, even actually before Cummings and Williams Harrell, I would have used Nolan to say an employer not only has to supply, but after Pape's case as well, which is one on the previous slide, he has to supervise, to instruct in dangerous cases. So I think an employer should have to supervise and instruct the wearing of protective gear, and therefore I think the scope for arguing Cummings by defendants has been very greatly limited. I don't see that discussion in tort textbooks. Well, there we are. I've done vicarious liability. I've done breach of the 4 common law duties. I now come to the statutory duties in the last 10 minutes or so. We've had a series of statutory duties in the 19th century. I've listed some of the acts there, the Factories Act, Shops and Offices and Premises Act, and so on. In the 1970s, these were consolidated into an important act called the Health and Safety at Work Act. And various detailed regulations were made under them. I've listed some of the regulations there. Let me emphasize that these statutes, these health and safety statutes, were not tort statutes. They were criminal law statutes enforced by the Health and Safety Inspectorate, as you'd be aware of, I think. You've heard of the Health and Safety Executive. And the breach was a criminal offence leading to fines, or even, in some cases, supposedly imprisonment, although there's very little imprisonment for breaches of health and safety. And there's very little fines, and there's very little inspection, but we won't go into that. leave that for a criminal law course. The importance of the breach of statutory duty criminal legislation was that tort judges got hold of it and started saying, if you're in breach of the criminal rules, that makes you in breach for tort purposes. That important sentence in black at the slide there, breach of the criminal law could also found a tort claim for compensation until 2013. There were advantages. There were advantages in this. What sort of advantages would apply? Well, the statutory duty, like the common law duties, was not delegable. There's no excuse to say you had an independent contractor. You were liable for the independent contractor if there was a breach of statutory duty. And there was liability for acts outside employment. Vicarious liability may not have succeeded. This was an advantage. Secondly, the burden of proof was reversed. This is important, isn't it? It was no longer for the employee to show that the employer was unreasonable. The employer had to show that he'd acted reasonably. The burden was upon the employer. This burden, switching the burden of proof, I think had a practical value. Good for claimants. And in some cases, there could be stricter liability for the breach. Now, this is blown up, I think, for those who oppose breach of statutory duty to out of all proportion. They said there was strict liability extensively. There was not strict liability extensively. That is not true. But there were some cases, like the Frost case, John Summers' case, you know, where there's a duty to defend certain dangerous machinery. And that criminal law statute says, you shall fence this machinery in this particular way. You shall do it. And there's an injury, and the employer is sued, and they rely upon breach of statutory duty, and the employer says, well, look, it's a nonsense. If I had to fence my machinery in the way that the statute suggests, I'd have to close the factory. It'd be uneconomic. I couldn't get things done. It was not financially proper that I should do that. And the court says, we don't care. There is strict liability here because the word shall is used. You shall fence. It doesn't matter about whether it would be reasonable to do so. If that's what the statute says, that's what you must do. That was one example of strict liability. There wasn't a great deal of strict liability in the law. It's a myth that the law on breach of statutory duty involves a great deal of strict liability. The fourth and final advantage was that the defences were harder to establish in breach of statutory duty cases. I won't go into that now. Well, when David Cameron came to power in the coalition government with Nick Clegg, one of the first things they looked at on the Conservative Party ideology, of course, is red tape and also compensation culture. And they set up an inquiry because they were worried about employers doing things over and beyond which they were required to do. They would take far too much care because of compensation culture. We'll come back and look at it next semester. Too much red tape, you can do that. You know, too much regulation, too much government interference, slowing down of industry, ruining of the economy by this. They commissioned an academic called Professor Lofstad to look at this and produce a report. And in Lofstad's report, he said he was a bit concerned about the fairness of imposing strict liability on employers. There was only a little bit of strict liability, as I've already said. But Lofstad said where he found it, he was concerned about it. And he recommended a review of strict liability. Lofstad report's perfectly fair. What did the Cameron government do with it? Well, the answer is, it didn't commission a report. It didn't commission an investigation into strict liability. It simply passed in a very short period of time. There was a piece of regulation going through Parliament anyway. They slid in Section 69 of the Enterprise and Regulatory Reform Act 2013. And in it, effectively, they abolished breach of statutory duty. Breach of statutory duty, as you see there, gives rise no longer to a civil law claim. You can still prosecute employers. The employers can still be criminally liable, but you cannot use that as definitive evidence of the law of tort. The employers now need to prove common law negligence. There's no more strict liability, not there was much anyway, And there's no more reversal of the burden of proof. That might be important. Now, the big question I'm going to leave you with in 5 minutes is, what's the role of health and safety law in tort now? How much difference has this repeal made? I should go downtown to talk to my friends downtown more on this, because I'm not a specialist in employment injuries. But I don't think it's made all that much difference. The Association of Personal Injury Lawyers complained bitterly about this repeal. But I don't think it's made all that much difference. Why? Okay, you got rid of the breach of statutory duty, but how are you going to prove a common law failure by the employer? How are you going to prove the details of that? What are you going to use to find out what good employers should be doing? The answer is, you've got to go back to those detailed statutes, those detailed regulations under the Health and Safety at Work Act. That's where your evidence of negligence is going to come from. If you're looking to deal with certain toxic chemicals, how those chemicals should be stored, at what temperature, in what place, in what circumstances, the period for inspection, the risk assessment, that's all going to be there in the statutes, in the criminal law statutes. I think the criminal law statutes are still being used as the way they always were, to put flesh on the bones of the common law. So I don't think it's made all that much difference. But I'm not practicing in this area of law, and I should go away and talk to the people who do are more. But you'll see nothing like this in the tort textbooks. An example of how the statute could continue to be relevant. There's a key regulation made under that set of regulations, and you've heard of this as well. Every employer shall make, so you must make a suitable and sufficient assessment of the risk for health and safety. You've heard of these risk assessments for health and safety purposes. I suspect you've heard of these. And if you fail to comply with that, that's evidence of negligence. And so if I'm a common law lawyer, I'm going to say the evidence of the employer's fault is that they failed to make a risk assessment. And I would rely upon the Health and Safety at Work Act regulations to support that. You shall make a risk assessment. But, just to counter that, just to remind you, causation, which we're dealing with this week, is a powerful tool in the hands of some independent employers. Remember Cummings and Williams Arrow? They wouldn't award the safety